She stressed that lawyers as professionals are regulated in their engagements and interactions with clients. Clients, on the other hand, are also required to operate within certain boundaries or parameters in their engagements with their lawyers. Today on Law Express, we discuss the lawyer-client relationship within the context of the obligations owed by the client to his or her lawyer. Stay tuned. This is Law Express. My name is Noella Seidu.
Sylvia Kudi is a private legal practitioner who finds fulfillment in a variety of activities. When not engaged in legal works, he takes delight in reading, listening to the radio, gardening, and contributing to community service initiatives. Esne Okujato, a private law practitioner and a law lecturer, she finds joy in both the pursuit of knowledge through reading and serving others through her profession. Noella Seidu, she is a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
In terms of what a lawyer would expect from a client, basically for us lawyers, we have to advise the client. So we would need candid information from the client. We are under a duty of confidentiality, so we would not reveal your information. But basically, I tell clients that we're like a doctor and mechanic. When you tell us all the facts, we have all the circumstances, and then we can advise you. The advice will be different if we do not have all the information. So you have to give us all the relevant information as much as possible. And it's good to give a whole offload, everything to the lawyer, then we can give you proper advice.
So it's better to give more for the lawyer to sift through to pick what is necessary than to withhold, waiting for the lawyer to ask.
Yes, because the client sees it from a different perspective from the lawyer. The lawyer is going to give you legal advice based on precedent, based on law. So once we have all the facts, we're able to see where we can situate your matter and how we can find a solution for you. Yeah. But if you withdraw some of the facts because you feel they are not relevant, it may be pertinent because we know what to look out for, and so then we can give you wrong advice at the end of the day.
Let's backtrack to how clients come our way as lawyers. We know, of course, referrals.
Yes.
We know just walk-ins where the person is in the neighborhood and sees your signage. We also know those that probably you have relationships with, family, friends, colleagues from other places.
Yes.
So the person books that first appointment. What do we expect? Because you are both checking each other to see if you are compatible to even begin the relationship at that point.
Yeah. What I normally do is that when somebody comes in and we're not familiar with each other, you have to put the person at ease. So not necessarily launching into what the legal problem is, but have a little discussion on what's your name and then introduce yourself so that the person kind of has an understanding of how you think, because the client is also doing an assessment based on the way you think and how you speak to them, if they are even understanding it. Before you ask them, okay, I know you've come in with a legal problem. Can you tell me in your own words what the problem is? And for us lawyers, we need to allow the client to speak for a bit before we interject, because once you interject, the client loses their trend of thoughts and then they would miss some of the pertinent information. So let the client speak out, say what the issue is, and then we can come back and then ask the questions.
I find that many lawyers in litigation are very impatient when it comes to listening to clients.
Yes.
Reason being that you know what information you actually need most of the time.
Yes.
And where the client comes in and is bringing all manner of irrelevant stuff. So instead of just going from destination A to B, the person decides to do a detour to E, F before coming back. I figure that that is the main reason why many lawyers interject. But for a very first meeting, that would be very unpleasant, and you're likely not to get the most out of the client.
Exactly.
What does the client have to do at this point?
I think the client will have to be mindful of the time of the lawyer, because a lawyer's time and advice are his talking trade. So you don't come and just say all kinds of things. So what I do practically is I'll be taking down my notes, and if I see that you're going where I don't want, I will tell you, let's get focused. Because as you said, as a lawyer, I know what I want, but you must tell me the story. Many cases just hinge on a few issues, but the person will have to tell you all the history about it. If there's nothing historically important about what you are telling me, I think I'll chip in and say, focus on this area that I think is relevant. So I think that you have to pay attention to how much time they think we can give them. And they also have to pay attention to when they call us, because they think that we are superhumans, we don't have problems.
Yeah.
We have problems, just that we are trained as professionals to solve problems of other people. It doesn't mean that we also don't have problems. And, you know, just as a client has problems, another person too has problems. Also a client, so they should manage the time well with us.
What I do is that when a client is coming, we allocate time.
Okay.
So they are aware before they come in that we have 1 hour to do the discussion. And so when I realize the time is nearly up, with a nicely inform them that, you know, we have just a little bit more time and I'm going into another meeting, but I need to also give you not a full solution, but based on the evidence or based on the information you've given me, advise you. So at this stage, then I can interject that based on what you have told me, this is what I would say, like a preliminary legal advice.
Yeah.
But we would need what? Further documentation.
Well, I remember a client coming to our firm with boxes and boxes full of documents.
Yes.
And 2 hours into the conversation, I didn't know where we were headed. And it can get really frustrating.
Yes.
Especially because most lawyers do not even charge for the first consultation.
Yes.
It's true.
I mean, if we could enforce that aspect where you know that, look, you are on a clock and
Yes.
you are being billed, maybe, just maybe, people will learn to summarize and give you the essentials.
Yes.
So now we've had the conversation about clarity in communication to your lawyer. You already talked about being honest about what your problem is.
Yes.
What is the next thing we should look at beyond, can we introduce the issue of the conflict check?
Yes.
And what aspect of that is dependent on the client to
Sorry,
make
Diana,
a decision?
before we go to the conflict check, I
Very
think
well.
there's something that's also pertinent.
Okay.
Because in as much as a client would speak to their issue, there's a need for documentation, especially if it's litigation.
Yeah.
So one of the problems is that clients coming, but they don't have any documents. And that is where people lose on very, very good cases. We've had it happen numerous times where, for example, it's a shareholder dispute, a shareholder is oppressed. But you need to have information on what contracts were entered into, what the incomes were, what the business, income the business earned, because at the end of the day, they have to value your worth or your shareholding in the company. So
Yeah.
if you don't have the information, the lawyer can't help you. So a lot of clients lose out on cases or when they have a dispute because they do not keep information. So for clients, every time you're entering into a contract, keep your email communications, keep your WhatsApp messages, keep every piece of paper. It may seem irrelevant then, but later on down the line, you could use it.
And most importantly, when you're approaching your lawyer, make sure you come with these documents
Exactly.
and not assume they don't matter until way into the litigation after
Then they
you've done
remember.
all your discoveries, and then
Yes.
probably trial is midway, then they say, by the way, I have this letter that could support this.
Yes.
And then it becomes a big issue as to how you can get it into the case.
Yes.
So can we go back to the conflict check now?
Yeah,
I don't know if-
before that, about being candid.
Yes.
I think that it shouldn't be limited, being candid shouldn't be limited to only at the stage where you encounter the client for the first time. I have experienced a situation where they are litigating in court over a house. My client's caretaker in Ghana had been sued, so we had to join the owner of the property because she was abroad. She had to give power of attorney to the caretaker, so she became a defendant too. Now, I was just there when I received a process from another lawyer, trying to from the plaintiff trying to join a buyer of a house that we're litigating over.
Yeah.
So I found out from the caretaker what happened. He said, oh, he was just driven out of the house. But based on the processes filed, I realized that my client had gone behind me and sold the house, a house that we're litigating over. So I realized that I had to come out. Based on her own documents, I filed a process, notice of withdrawal, and the judge agreed, and I came out.
Took yourself out of the case.
Yes. So I think that they shouldn't think that they are too smart.
Yeah. Because it borders on integrity. At the end of the day, the lawyer is your mouthpiece. You can't be seen to say that, oh, I didn't know this about my client. But that doesn't mean that if they're trying to mess you up, you shouldn't take steps to protect your integrity.
Exactly, yes. So, respect of the conflict check. In the first meeting with the client, it is essential you do a conflict check. And the thing is that after the client starts telling you about their dispute, it's the best time to stop. Now, in our law firm, we're pretty large, and we have different partners who work on different things. So as much as possible, we try to do the conflict check before the initial meeting, apart from those who walk in, then it's a bit difficult. Because if you are conflicted and you receive information from a client which is against yours, what then happens with that information? There's a bit of an issue, even from your client's perspective, when they find out that you had spoken to somebody else who has some other disputes in respect of them. So it's good if you're able to do it before the first meeting. But if you're not able to do it before the first meeting, once you come in and the client start telling you what their legal matter is, sometimes, depending on the fact that it is not urgent, you can ask the client that we would need to hold off here in respect of you giving me information. I need to run a conflict check. When I run the conflict check and I realize we are not conflicted, we would schedule a meeting. So even at that time, because some clients may feel you do not want to represent them, it may be best to schedule the meeting then and there. It will take you a day, it will take you 2 days. You know how long it will take for you to do the conflict check. So you tell them conflict check takes 24 hours or a day. If it's a holiday, maybe a slightly longer. So that means we should schedule a meeting maybe a day after the conflict check. We would revert if there is a conflict, and then you can come in thereafter.
And that is why, once again, clients have to be candid.
Exactly, yes.
You can't come and give me a hypothetical situation just to test the waters. Where you go like, oh, assuming I'm suing this person without mentioning names. Because then it ties your hands up. How do you even check to be sure you're not conflicted as a lawyer?
Clients must know that as lawyers, we don't deal with assumptions. We are not science students. We deal with facts. And about a conflict check, once a lawyer realizes is conflicted in a matter, a client should understand that a befitting substitute will be recommended for the case to be done. Because sometimes, as you said, they think that you are refusing to do the case. That is not it. We assume that every lawyer is where he sought. So another lawyer will have to take it. If you don't have any, we all have colleagues, oh, can you look at this for me because I'm conflicted? And you have to understand.
So we'll go for a quick commercial break. When we come back, we'll pick up the conversation from this angle.
Okay.
Stay tuned. We'll be right back. This is Law Express.
Of the engagement, like you said, it's always relevant that it is in writing. That helps both the client and the lawyer know what the terms of engagement are. The client is aware of what the fees are. If it's on an hourly billing, they know how fees are calculated. They also know when the fees are due, which is extremely important. They
Especially to the lawyer.
Exactly. They also know what costs are involved. For example, transportation, they have an idea of how much it costs, photocopying, what have you.
Administrative costs. Yes.
Exactly. And for me, one thing that is pertinent is that for the clients to understand that the fact that I've been engaged for this particular services doesn't mean I'm providing all your legal services. That's not what it is. I've been engaged for a particular matter. If you have another legal matter, we need to enter into a new terms of engagement.
For that particular
matter, exactly. So it's fairly obvious. You don't want your lawyer to feel that they've been taking advantage of. That kind of sours the relationship. And then when the lawyer is asking you to pay certain monies as well, then the client doesn't understand the basis of it. That also affects the relationship. Yes.
So it's not that simple to say somebody is your lawyer when you haven't put the person on a retainership.
Exactly, yes.
But it's a common thing where, because there's a relationship, maybe even social or family,
Yes.
they are quick to pull out that name, like, this is my lawyer.
Yes.
And at that point, probably you're even not doing anything for the client, but they insist that you are their lawyer.
Yes.
So it's not that simple. There is some background obligations that make as one person another's lawyer.
Exactly.
I think a better way they can say it is that this is my lawyer, a lawyer who is my friend. But to say this is my lawyer, it connotes there's some form of contractual obligation between the two of you.
Yes.
As you rightly said, family members assume once you're one of them, you are their lawyer, but it doesn't work out like that.
Yes.
And we do a lot of things free. And we also need to make some coins. So when they come and we are doing free things for them, they should be patient.
So clients have to respect lawyers' time. You
Yes.
mentioned this earlier,
Yep.
but I'm bringing it from another angle,
Okay.
where they just call you any time of day. So once you've signed those terms of engagement, they just assume that they own you. So they call whenever they like, middle of the night, they text whenever, email anytime, pop into your office and expect that you give them undivided attention.
Yes.
Clients have to know that they are just one of many clients you have. So they should respect the time you schedule for them, book meetings per hour,
Yes.
even phone calls.
Yeah.
Somebody who has some courtesy would text ahead, unless of course it's an emergency, to say, oh,
Yes.
can I talk to you at this time of day? And then you clear your calendar for that. Because there are so many other people you're working for, and you cannot possibly be there for everybody at the same time.
Yes, I quite agree with it. And one thing clients need to understand is the health of your lawyer is important. I mean, little digression, but if your lawyer is not healthy, your lawyer cannot provide you a service. So if you are calling at all times of the night, when is your lawyer supposed to
Rest.
rest, relax? We are not machines. We also need to have family time, which is extremely important. So the same way you want to make time for yourself, you also have to allow that lawyer to have that time. We do understand that there are emergencies, and sometimes you have very short timelines to turn back on a contract because you have to give a decision and so on and so forth. So it will be factored when you are engaging the lawyer. And so it's always relevant that the client lets the lawyer know at the onset how much time they need feedback.
Yeah.
Then the lawyer also works it within what their schedule as well. So yes.
Yeah, and talking about feedback,
Yes.
there are clients that you make requests from in terms of some information, documents. There's a trial ongoing.
Yes.
You expect, and we work with timelines.
Yeah.
So you expect this lawyer, this client, to bring the information a week before, and they show up the night before with the information, and
Yes.
it makes it impossible to work with the person because you are messing up your own case. That's just the
Exactly.
reality.
Yes.
But then in doing that, you're pulling down your lawyer as well because he goes to court or she goes to court looking like they don't know what they're up to.
Yes.
Because there are rules to this game. And when you delay with feedback, just like how you would feel irritated if your lawyer delays giving you feedback, you should also consider that you lose more if you fail to do that.
Yeah. So I quite agree. And basically what
here.
we've been doing is that we would send an email
Reminder?
indicating a reminder and then also giving the legal implications.
Okay.
So if you are late, and I think for us, we need to do that because at the end of the day, when the client loses, the client will now come and say, you did a bad job.
Yeah.
And then they report you to the General Legal Counsel. So to avoid all of that, you make it clear that you have informed them.
You see, what you just said, I think is applicable to people who can read.
Yeah, I like that.
We are very large.
Yeah.
I'll send a voice note on WhatsApp in the language that you understand.
Yes.
Well, what if you don't understand that language? Of course, you took instructions in a certain language, so you can do
Yeah.
that in that language. I think I agree to that. But,
Yeah.
But there are
email,
people who just delay unduly with
Yes.
everything, every step of the way. And
I agree.
you even call them to come and sign processes, and
They're
they
not
take their sweet
coming.
time.
Yeah.
they are busier than their lawyers.
But it's your case. So,
Yeah.
I mean, you should understand that there are consequences to
I
all
don't
of
know
these
how
things.
many Ghanaian clients understand the fact that the case is theirs. They treat the case as is for the lawyer.
Yeah.
Once you are in charge now, I've handed everything to
You are
you.
the magician on duty.
Yeah, so even evidence, they expect you to tell them what to say, you see, which is difficult.
Great.
And one other thing you may not maybe you may not have experienced, but a number of people have experienced, is that clients trying approaching lawyers to go and see judges for them.
Yes.
From day one, I will tell you I'm not that kind of lawyer.
Yeah.
So if you are that kind of client, then just don't come to me.
Exactly.
So the lawyer cannot do anything. The judge is there, the lawyer is here, they don't know your case. You know your case, so narrate your facts. Your lawyer will do the best for you if you are candid.
Yeah.
You don't need to go and see anybody with any money.
Yeah.
Yes. And it wouldn't even help your case because you are bribing the judge. It's against the law. Morally, it is also wrong. And the issue is that it's like politics. You know, people pay politicians or politicians pay people to vote for them. At the end of the day, you don't know what they really do.
Okay.
So how can you tell that if you give the judge the money, the judge is going to rule in your favor or do something?
How do you even get the judge? I mean, it's not that simple.
No.
And it's important that clients know that sometimes the people who pretend to be doing that
Yes.
actually are not talking to these judges.
Exactly.
Because there's no receipt going to be issued. How do you even know they did?
Yes.
So somebody can just deceive you and mess up some judge's name.
Yes.
And if you're lucky to get it your way, you assume that the judge played ball. Meanwhile, this judge knows
don't
nothing
even
about
know,
it.
yes.
So it's just too
Sometimes
risky.
maybe it's a source of pride for them that I'm well connected. This is my case, so my lawyer has gone to see the judge. They brag about it, which to me is totally wrong.
Yeah. So I find that what I tell my clients is that rarely does it happen, but in the off chance that it does, I would say, look, at the end of the day, it's against my professional ethics.
Yeah.
I stand to lose my license to practice, and this is how
Because
I
of
earn
one
my
case.
income.
Yeah.
And I am not going to make that decision on you. You are on your own. I have nothing to do with it. I am not going to do with it. If you do go to the judge, and I do find out, I would not proceed with your case. So if you really want me to help you with your matter, then don't do it.
And I expect that if any client approaches a judge as well, I'm sure they would know what to do with that person.
Exactly. Yes.
You mean the judges?
Yes.
I'm not sure we've seen a lot of results because our law on corruption and bribe giving itself facilitates that process. I keep saying this. If you have a law that says that a giver and taker are equally guilty, why will I come and give you money to facilitate the process for me and I go back and report that I've done that so I arrest both of us? It will never happen. So unless we look at our law, looking at our circumstances, other than that, we will not get anywhere.
Very well.
Because the takers are ready to take.
Well, you never know. We sampled people's opinion on today's topic.
Okay.
So we'll listen to them and then
Sure.
give our feedback.
Clients hold a lot of responsibility towards their lawyers, and most of us know as lawyers, they are the ones supposed to represent the client during court cases. So as a client, you are supposed to give your lawyer all the necessary information they need to be able to proceed to represent you during court cases. Also, you are supposed to make sure that every detail that you think necessary or unnecessary, you are supposed to tell them clearly into details whatever that has transpired so that they'll be able to represent you well. Clients are also supposed to actually exercise their financial duties towards their lawyers. That's actually paying up the amount of money agreed upon between them and their lawyer. Clients are also supposed to make sure that in as much as the lawyer is representing you, you're supposed to make sure that phone calls, text messages or emails will be answered in due time because the lawyer has other clients that they are taking to us. So clients should actually pay courtesy to the lawyer's time.
Okay, so some of the obligations clients have towards their lawyers are to be cooperative, to be open, and then to give them right information about the situation, just so they can have the lawyers to help them and then make it very easy for the lawyers to handle their cases.
Clients' obligations to their lawyers. Clients are supposed to treat their lawyers and lawyer staffs with courtesy and consideration. Also, clients are supposed to honor the fee arrangements as agreed with their lawyers.
The obligation of a client towards a lawyer is to listen to whatever the lawyer asks him or her to do in wherever they find themselves, and also make the lawyer comfortable in terms of finances, being able to pay any amount the lawyer asks him or her to pay. in order for him or her to carry out the case successfully.
A client's obligation is to be honest and give relevant information to the lawyer. A client has to be honest by giving vital information for a successful outcome.
Clients should be ready to expect and understand the result of their case without any doubt or challenging the lawyer, since the lawyer knows best.
I think that they were spot on, especially the person who talked about not challenging a lawyer. You can challenge a lawyer, but not on the law. I've had some clients who come to you from another lawyer, and they will try to damage the reputation of that lawyer before you. I've had that experience. So I told them point blank that just as you are talking about this colleague to me about this case, the same thing you're going to do to me. So I'm sorry, I cannot help you. So I think that once you have that relationship with your lawyer, trust the lawyer. If you didn't trust the lawyer, why then did you go there in the first place to see him?
I also like the fact that they said professional judgments, which means that when the lawyer gives you an opinion, take it for what it is. And use it, in as much as sometimes we'll give you news you don't want to hear, because we will tell you in a particular transaction or a contract, the terms are really bad, they don't make sense for you to proceed. And you see the big money you are likely to make and don't see the fundamental problems. You're only looking at how much you will end, but there may be clauses which will actually claw back all that money that you're going to end, so you should keep that in account.
The standout for me was the part where they all kept saying, pay your lawyer his fees.
Yes.
It's very important. You're taking somebody's time, expertise, experience. The least you can do, I mean, naturally you can't quantify anybody's time in monetary terms. But the least you can do is to show appreciation. Yes, you have an opportunity to negotiate what you can afford. If the lawyer feels that you are justified because you don't have money, the lawyer can elect to do the case on a pro bono basis where you don't have to pay. But even at that, there are many strands to that. There are some pro bono cases where you still pay your expenses only without the legal fee. And there are times the lawyers are so touched to the point that they are willing to even take care of your expenses personally. So if you're honest, once again, about your situation and it's a genuine challenge, I'm sure that most lawyers would help you on a pro bono. And there's also the option for this contingent fee arrangement where, yes, you don't have money today, but your case is very good. And probably you have a higher possibility of success. And when you do, you agree that, lawyer, fund everything, pay all administrative expenses. And when I get a judgment, we can split the amount in a particular manner. So there are many ways around it, and that's why it's important to be honest from the word go, so the lawyer knows how to assist you.
I found it intriguing that every single one of them talked about paying the fees. I wish clients really were like that all the time, you know? That would be the best to ever have. And the thing is that if you are having, yes, people go through things where people have financial difficulties. It's best that you let your lawyer know you have a financial difficulty, so can we split the payment terms? The original agreement, I may have issues meeting that now, but I can split it up. So that the lawyer is aware, but not avoiding calls of the lawyer, not picking it up, not responding to emails. And then the worst, like you said, is when there's a matter in court and the person has to give you a document and they're avoiding you because of the fee, so they're not providing you the document. I mean, how can you do the case for the person?
They'll leave you unarmed.
Yes, exactly. And then what people don't realize is that you make the lawyer look silly before the judge. Because it's like you brought a case, your client was supposed to bring certain documents, maybe the other side needs. You go to court, the documents are not available, but it's for some excuse or the other. So it's like you are not doing a good job when it's not necessarily you. So yes.
To add to that, about the payment of fees, if clients think that once I don't pay lawyer A, I can take my files and go to lawyer B, it doesn't work like that.
No,
because
it doesn't.
ethically we're supposed to find out that there are some liabilities to be settled. If they are not settled, the next lawyer cannot take the case.
So can you explain that further, like step by step, how it works? You probably were working with a client, the client decides to stop, terminate abruptly. But probably the client had copies of the file, so they take it to lawyer B. let's walk them through what is likely to happen.
Okay.
Or what is supposed to happen.
Lawyer B, the new lawyer, is supposed to contact the earlier lawyer.
Perfect.
To find out what exactly happened.
Yes.
Because once you are not a lawyer withdrawing from the case, you are not supposed to file a motion to do that. If a client is coming for his file, he is supposed to do that and give reasons why.
Yeah.
Either he's going to represent himself
Yeah.
or going to hire a new lawyer. But before the new lawyer comes into the picture, ethically, he must find out from the first lawyer what exactly happened.
And if you think it's just something that we say, if the new lawyer fails to follow this ethical requirement, you put that new lawyer in trouble as well.
Yes.
Because the person will be acting unprofessionally and could be punished
Yes.
for failing to check with the first one. So you think you're escaping liability of payments of bills, but then you end up in a big problem.
Exactly.
Yeah.
And then one thing is that under ethical rules, the lawyer has a right to actually place a lien on the documentation
Yes.
and keep it pending the fee. So you are better off negotiating with that lawyer. I can't pay you right now, but
Yeah.
once I win my case, this
Yes.
is what it is.
Yeah.
And the new lawyer is bound by that agreement between the client and the former.
It's important to stress this because I've seen a situation where one lawyer carried a case and just when they're approaching judgment, client terminates because he saw that they are likely to win.
Yes.
And then took it to a new lawyer. Why? Because the first one who did all those years of work would have collected more money than the one who just comes to collect judgment.
No.
So let me like save some money by going to
Yes.
somebody new. Only to realize that it wasn't that simple. You still pay everything that is owed, and now you have a second person to pay.
Exactly. So it
So
ends
you
up
don't
costing
win.
you much
Let me
more.
give you a practical
Yes.
example. I think the case is still on.
Yes.
I'm doing a case that it's a divorce matter. But my client is telling me the property involved had been sold by him to the sister. So I decided to join the sister because I've seen documents to that effect.
Yes.
Now, I was just then, I received a letter from another lawyer saying that the person I had joined on her instruction had engaged her. So
Okay.
she wanted to take, he wanted
Over.
to take over.
Yes.
All because I was doing this case pro bono for the brother and she came in. I didn't
Yes.
ask you for any payment. You sent me email to find out
How much.
And I sent something small, you complain, so you can check with the scale of fees.
Yes.
It's on our website. He didn't do that, but he decided to avoid me.
Yes.
He went in for another lawyer. So based on that again, I quickly just withdrew.
Thank you.
Now the case is in a limbo. The brother now has come to me that let's try and settle because the property involved, the woman is also claiming an interest. Can
Yeah.
we get a buyer so that, and I said, okay,
Everybody
that's
can
smart.
split the proceeds.
That is all.
Yes.
So you see, they think they are smart, but they cannot always do
It
that.
wouldn't help you at all. Yeah.
We'll go for a quick break now, and then when we come back, we have some questions coming in through our social media
Very well,
handles.
very well.
We'll try to answer that and then
Okay.
wrap up the conversation.
Hi, Noella and esteemed panelists. I hope you are all doing well. I recently encountered a legal situation in Accra involving an inheritance case. During discussions with my lawyer, I noticed he didn't especially inquire about a particular detail that could be significant. Now, I understand the importance of being forthcoming, but do I have to disclose everything even if my lawyer doesn't ask directly? I want to ensure I'm fulfilling my obligation as a client. So I would really appreciate your advice on this matter.
So yes, every detail is important,
Important,
and you need, especially when you are aware of the fact that it's pertinent, your lawyer hasn't asked it, you should give that information out. So whatever information you have surrounding your dispute, you give it to them. I say lawyers are like doctors. I mean, you have a tummy ache and there are other symptoms because we give advice based on the symptoms or what you say.
Yeah.
If you leave out one detail, that can actually undo your entire case and make you lose it. So give every detail. Once you feel is pertinent, give it out to your lawyer.
In other words, it's better to be superfluous than to be limited.
Exactly.
So give as much as you can for the lawyer to do the sieving.
Yes.
I mean, it's said that even the devil cannot tell what is in a man's mind.
That is
Yes.
You realize that this information is important.
important.
Why did you withhold it? Unless, of course, the lawyer shut you down at some point, but that was not part of the question. So it means that you decided to keep that with the hope that the lawyer will
Information,
pry
yes.
more.
Yeah.
But every case is unique, and he clearly or she clearly would not know all the little bits of the case. So
Yes.
tell everything you have to.
Well, I think that to be fair to clients, to as lawyers, we should also be asking probing questions.
Yeah.
Because sometimes clients may not be telling you the truth. They'll paint only their side of the story. But if you begin to cross-examine them in a way, you realize where they are getting to. That's not where they are supposed
There's
to go.
something else.
You know, you find out.
Yeah.
Hello, Team Law Express. I'm dealing with the aftermath of a tough situation. I was sexually abused in Ashaman. I've been working with a lawyer to seek justice, but I'm starting to doubt he is the right fit for my case. The assault by someone I trusted left me shaking, and I've relied on legal help to navigate this painful process. However, I feel like my lawyer isn't fully fighting for me like I need. Now, I'm considering changing lawyers to make sure I get a justice and healing I deserve. Has anyone been through something similar? How did you find a new lawyer, especially in such a sensitive situation?
So the issue is that, I mean, she didn't particularly say what was wrong with what the lawyer was doing. Now, in our legal field, we have various expertise. So you have certain persons who are criminal lawyers, and from what she is saying, this is a criminal matter. If you go to a corporate transactions lawyer, they have absolutely no clue what it is. So you need to be sure that your lawyer has experience and has expertise in that subject matter. Also have a discussion with the lawyer what your problems are, and then hopefully you are able to resolve it. But ultimately, if you feel you are not getting the proper service that you need, it may be best for you to go to a different lawyer.
I feel that the question is not complete.
Yes.
Reason being that if you're talking to a private practitioner with a sexual assault case, are you seeking compensation? Because he says the lawyer is not prosecuting the matter. So then it suggests that you go in underthought to find some compensation for the abuse you suffered. If not, it's the state that's supposed to prosecute your matter because it's a criminal case. So I wish the questioner had given us more details. And once again, this what could have happened at a consultation. If you don't give it all, it's harder to advise you.
Yes.
Because if it's taught,
maybe
then
the
you go with
lawyer
what?
The lawyer will also be holding watching brief in that
Yes.
case. So
Yes.
there's that possibility.
But
to
if
that.
you're watching brief, what are you prosecuting? You're
There's
just
not much you
supposed
can
to,
do.
you're just shepherding and watching the
Maybe it
process.
depends on what he's told the client.
Yeah.
That I will do this for you, knowing very well that is not your domain.
Because there's nothing to do with a watching brief.
Exactly.
Well, depending on what it is, I mean, you can speak with the prosecutors and assist if they are willing.
Yep.
But you can't fight.
But you cannot, there's nothing you can do.
They don't
Your
listen.
lawyer
And the
at that
prosecutor
point
doesn't
is
have
the
to listen
prosecutor.
to you.
Yeah.
The court will
Yes.
not even listen to you.
No, at all.
The lawyer at that point is your lawyer at that point is is the prosecutor.
Okay.
The
Yes.
state gives you a lawyer, and then so that's where you should go, perhaps.
Dear Noella, my situation is a bit funny, but quite serious. I initially sought out a lawyer to assist me with a legal case I was facing. However, as time passed, something unexpected happened. I developed feelings for my lawyer, and it turns out she's single too. Now that my case is over, I find myself seriously considering the possibility of marrying her. Is it ethical or appropriate to pursue a romantic relationship with my lawyer after our professional engagement has ended? I would appreciate any advice or insights you and your panelists can offer on this matter. Thank you for your guidance.
I know Mr. Okujeto's position on this. He will tell you no. He taught me legal ethics.
Yes.
Yeah, I remember.
Yeah.
You know, we happen to be classmates in the law school. So he would tell you no.
Yeah.
So I also say no.
Yes.
After the fact of the case?
Yes.
Way after?
This was exactly the question I asked Mr. Okujeto 18 years or 19 years ago. I think 18 years ago.
Yes.
And he said, no, it's a no-go area, even though the contract is over.
So there was a bit of an issue with the question. I think some information was left out.
Yes.
Because the person said he developed feelings for the lawyer. And now, after the case is over, he wants to get married to the lawyer. So they must have had, there's a presumption, there may have been some relationship, because you won't just come and say, I want to marry you at the get-go. And so our etiquette rules are very clear. No lawyer can have an amorous relationship with the client.
Is that the practice though?
Yes. So, no, that may not be the price. So the female, if it is true that something happened, then the female lawyer, to me, was not acting right.
Yes.
Well, how I heard this question,
Yes.
or read this question, is a bit
Yes.
different.
Yes.
Okay.
I want to believe that Sam Okijito, Esquire,
Yes.
18 years later, probably might change his mind with the current trend of things. First of all, I do not know what services the lawyer provided.
Okay.
If it was just a conveyance and some drafting of some documents, and it wasn't like something that had to have them like share too much personal information, I do not see anything wrong after the contract. Probably there's a time lapse of some years to reconnect and have a relationship. For as long as that did not start during the pendency of the contractual relationship. Senior Savior, you can meet your partner anywhere. For as long as you're single, if this person means well, and you did not start anything wrong during the period that you were providing your professional services, and then probably 3 years later, the person wants to take you on a date and propose marriage, for me, for as long as there's nothing outstanding, I do not think it's that bad. Unless, of course, there is another thing where maybe you were part of a divorce, some divorce proceedings, and a lot of information ran through, then, well, borderline. But even at that, if there's some time in between, and you still think that of all the bad things that his or her spouse said about him or her, you still think this is your angel, and you don't have any contractual obligations towards each other to influence anything, why not? We'll come to the wedding.
So your position is that once the contractual obligation is over,
not just over simplicity, there should be a time lapse. And you should also check, it's an integrity thing. When you have that,
I may have a resolution for the two of you. Etiquette rules actually say it is during the client-lawyer relationship.
Exactly. So if it's a day after,
if the client-lawyer relationship is over, then that helps. But I mean, each circumstances would play on what is the best way to go forward with that relationship. But once a lawyer-client relationship exists, you cannot have.
So that relationship can start like the day after.
The old man will still stick to his position. It's a no-go area.
You never know. You never know. Perhaps you should take it up again.
In respect of termination, just for the client to know that under etiquette rules, a lawyer can terminate for non-payment of fees. So basically, if you don't pay your fees, a lawyer has a right to terminate your engagement.
But that gives her a lot of work because you now have to go and maybe I've done some work that there's some accrued interest. I have to go now sue. What I've observed is that maybe the lawyers are always in too much of a hurry. We don't issue the notice before we start. And at the end of the day, they tell us we didn't start well.
But that's a procedural thing. Because you need to seek their leave.
It's always caught up with us, and I don't know why.
And then we don't have engagement letters as well. That's also another one.
Because people just flow in from relationships. Like you meet the person at church, it's like I have this problem, and the consultation starts right outside the church premises. So they just say, okay, I'll send you documents. Before you realize you've done the work,
moved on,
and you haven't even had that first sit down. The next time the person shows up to your office, they're just bringing you documents. And then that's it. Along the line, they now decide how much to throw at you every now and then, either around the courts in an envelope or
it's a society
through somebody. So you realize that you finished the case and you didn't really quite agree as to how much. And when you now want to pick up the conversation belatedly, they're like, no, that's too expensive. And then it becomes a tussle. But termination could also occur, like in the situation where a client develops feelings for his lawyer or the other way around. Once that happens, the lawyer has to withdraw his or her services.
And do honest.
And stay away, disengage, because it's unethical.
But I'm terminating because of the feelings I have. Why should I lose the case and lose the feelings too? So I have to go in for the feelings.
So you go for the feelings?
Of course.
No, but you'll be in more trouble.
the basis for termination is that
Yes.
I am interested.
Yes.
So why
Okay.
should I terminate because I'm interested and I'll not pursue that interest?
interested
No.
before the termination. And that puts you
So ask
wrong.
the person you are now having the feelings for to get you a good lawyer so that they can continue the case and then you can go on your feelings, right?
So you're saying choose the person or the case,
Of course.
but don't lose them both.
No. It can't happen like that.
Well, we've already talked about the fact that lawyers can sue for their legal fees.
Yes.
We have to keep repeating it.
Yeah.
That is not that simple. You might think you got away with it. If the paperwork is right and the lawyer has all his or her records, you end up in court. You finish the matter, you start a new matter over the legal fees.
Yes.
Then there's also the issue of accounting, where lawyers have to keep separate accounts.
Yes.
So their own accounts separate from clients' money.
Yes.
So the money you pay for them to do filings and all of that has to be separate from whatever you've paid as legal fee, which is the lawyer's service fee.
Yes.
And that money has to be accounted for, the one that belongs to the client for administrative and other expenses.
Yes.
And you have a right to insist on that with evidence, supporting receipts and all of that,
Yes.
such that if there's a difference or a balance, you can take it.
And it's a right clients can insist upon.
Yes.
They can come at any point in time to ask for a statement on how much they have
client
put
account,
in.
yes.
You can be disbarred, basically a lawyer can be disbarred for not keeping clients'
Money
funds
separate.
separate from their fees. But in terms of the fees, a lawyer can lay a lien on it.
Yes. So
Yes.
if you still have money in your account for your expenses and you're not paying legal fees,
Yes.
the lawyer can decide to attach that one at this point.
Especially when you move to another lawyer because you do not want to
See,
pay the
what they are
fees.
talking about is about for high-end
Clients.
clients.
They will have,
Majority of
because
the
majority will have very little money in our
Yeah.
pockets, exactly.
Finally, can we talk about boundaries and respect for your lawyer? Clients think that because of familiarity over time, they've been hanging out with you because of long trials and then pre-trial engagements. So they think it's okay to just touch you like, oh, lawyer, laugh and then smack you. And please, no. You
It still is a professional relationship.
Yeah.
And in as much as you become familiar based on the case and the time you spend together, there should be some boundaries
Oh, yeah.
within how you operate within each other. And the touching, some of the language that is used, which is too familiar as well, it's really not the best.
like
especially
sweetie,
Exactly.
and stuff, especially to females.
Yes,
It's off.
completely off.
There is this category of clients who think their lawyer's competence is tied to the quantum of gray hair they have or their biological age. Some lawyers go to school pretty young,
Yes.
so they might look tiny, young, but could be way senior and very experienced.
Yes.
At the end of the day, it's about who can give you what you need in terms of legal services. And don't assume that because this person could be your child,
Yes.
the lawyer is your child. So you have some clients talking back in very unsavory manner
Yes.
to lawyers. For me, I just withdraw my services.
Yep.
Because you can start shouting at your lawyer and talking and suggesting that you can be my child, my daughter, so I'm allowed to talk to you that way.
Yeah.
And the other group is those who think that if you're a woman, you are not a great lawyer. So they want to see Papa lawyer. They don't want to see any
see
woman who
you,
is a lawyer because
exactly, yes.
women are supposed to just be assisting the lawyers as secretaries.
Yes.
So
So I mean, when I find myself in these situations, I actually put them on the table and I actually say, do you want to have legal advice? Do you want to have a competent person to advise you? Because I know what I'm done. I know what I'm about.
Yeah.
I've done this for quite a number of years, so I can assist you. But if you want to insist on being in that way and manner, then you would have to leave. Basically, you're not going to get the advice that you really want. And it has helped me such that, I mean, you walk into a room, people see a young lady, so they think you're not qualified. I sometimes take it as an advantage, depending on the circumstances. If you enter a room to do a negotiation for the client and other people feel you're just an empty head,
underdog.
it helps you because
Yeah.
then they're not ready for you. So when you do start, I
take
mean,
them
then
by
they
surprise,
sit up and
yeah.
they're like, oh,
They underrated you.
you underrated me. And I've had it where I've had a client and then I'd go for a meeting. Maybe they have another client, they're negotiating a contract, and I walk in. he would tell them, don't underestimate, don't look at this and think that there is nothing. My client actually would tell the other side, and I think that helped me in those kind of circumstances.
Well, when these things happened to me,
Yes.
one time this was the reaction, oh, I underestimated you. And
Yes.
to her it was a compliment, but to me it was more offensive.
Yeah.
At this point, we would have to wrap up our conversation. It's been awesome having you both
Yes.
on the set. We hope to see you again sometime on another topic
Yes.
because it's been great. You have been listening to Mr. Xavier Kwaku Kuji and Esne Okujito. I don't know. I didn't want to add a miss.
No, I've maintained my name, so that's fine.
Yeah. My name is Noella Seju, and this has been Law Express on the topic, the lawyer-client relationship within the context of obligations owed by the client to the lawyer. Thanks for staying with us. Until next time, this was Law Express.